He came back and he said, Mom, he said, if anything ever happened to me, just know that Tim did it. What are you talking about? He said, well, just know Tim don't never do his own dirty work. But I got that fatal call from her about Dre, and I didn't want to answer the phone. You know, I just didn't want to answer the phone. And then she hung up and she called right back. And then that's when she was like, well, you know, the detectives was here. And already my heart is already slowing down, you know, and to the point where they want her to go down to the morgue to identify that was him. That was it. You know, it was like, it was so surreal. Everything was just rolling around. I'm just like, not my son. You know, not my son. Not my son.
What's up, good people? Welcome back. Let me know that you can hear me in the chat by typing day 3 or justice for Dre, day 3 or justice for Dre, because we are still doing our transcript reenactments and we are on day 3 of the transcript reenactment. We're making our way. I know it sounds like just day 3. We've been doing this for months on and off, and I had to take a little bit of a break to just kind of juggle some things out. But I am glad to be back with all of you over here. And just keep in mind that yes, we are doing the transcript reenactments over here on this channel. But after this, pretty much immediately after this, we'll be on the main channel, the Vell B Reacts channel. And we will be going over the episode of On the Case with Paula Zane. The episode was titled The Bitter Truth, and it is an episode that is dedicated to Andre's story and getting the truth out. We tried to do a live watch party sort of situation. What was that, a week or so ago? And unfortunately, it got blocked. YouTube yanked it down. Well, it's still available in some areas, but it's a lot of people still can't see it. And on top of it, it cut us short and cut my commentary short. So we will be doing it again this evening because I've been getting a lot of requests for some people who didn't know we did it at all because it did get pulled down in certain regions, and other people who were watching but feel cut short, felt cheated. Because when they went back, they couldn't see it, etc. And they wanted me to do it again. And so I got a lot of messages and I was like, okay, so after this, we will be doing that. And then tomorrow we'll be live. And then Friday we will be live. So, so today we are continuing where we left off, I want to say 2 weeks ago. And if I'm not mistaken, we're on the testimony of Big Ed. We have our cast here again tonight. And we're just gonna kind of get right into it. We have, let me see what order I'm gonna pull them in. We have Precious G, we have Robert, we have Mocha Barbie, we have Marjan, and we have Shamika. Welcome, cast. Let me get us all situated. Pull this down. Share the screen. Share our document. And we are continuing where we left off. We cut it short and left off right as the court was resuming and was resuming from a break, I think. Or I don't know, it's a little like a sidebar or something. So they were resuming in open court. So we're on page 125, line 22, where it says proceedings resume in open court.
Pose another question of the witness.
That's you, Margin.
Oh, sorry. Hold on. Sorry, I was trying to. Sorry. 25. Mr. Rogers. Okay. Yes, thank you, Judge. How did you get down to the funeral?
I drove.
Did anyone drive with you?
Yes, Bruce and a guy named Randy.
When you traveled down there, did you travel armed?
Objection, relevance.
The objection is sustained.
Did you know if anyone that Bruce and Randy did they travel with firearms?
Objection, relevance.
The objection, again, is sustained.
Were you there as an employed person, or were you there as a judge, as just a guest?
Security.
And as a part of security, did you carry your firearms with you?
Objection, relevance.
Counsel, the objection is sustained.
Okay. Who hired you as a security for the funeral?
Tim.
Did Tim express to you why he wanted security at the funeral?
Objection, calls for hearsay.
Did Mr.
The
Norman
objection is
give you
sustained.
any reason? Oh, sorry.
The objection is sustained.
Sorry. Did Mr. Norman give you any reason for why he wanted security?
Counsel, that's hearsay. The objection is sustained.
Okay. What was your understanding for why you needed to be at the funeral?
Same objection.
The objection is sustained. Pose, if you will, come here to the sidebar.
Here we go again.
Sure.
Here we go.
And remember, this was Tim's primary attorney. This is the person he hired. Michael Leonard was an add-on. This is his primary attorney. Well, was. Proceedings were held at sidebar, so that's we as the public, we could not hear in the courtroom. They had the white noise playing, and they are now talking on the side of Judge Ross's bench.
Counsel,
I'm not getting into the statements. I'm just asking.
you are asking the exact same thing that you were bringing up here at the sidebar. You have asked it a number of times, counsel. The record is clear. Now, you have made your point that you want to ask this question. I have sustained the objections For the record, at this point, I'm going to ask you to move on to a different issue.
Okay. If I can just complete the record, Your Honor. Your Honor, again, it is the effect on the listener, but also I don't get into the statement that he heard. These statements from Tim are not for the truth of the matter asserted, but what he did while he was at the funeral. What the suspect witness said, it is not based on hearsay. That is, I didn't even ask about the statements were. I rephrased the question to avoid asking him what the statements were.
The statements, what was your understanding of why you were there for safety? Call for inference of hearsay. The only reason that he would be there is, I gather, you want to get in that Tim asked that they be armed. And that is not relevant. Number one, it is not admissible through this witness. So I'm going to sustain the objection. I'm going to direct you to move on.
Okay, understood.
Judge, since Ms. Rodriguez is ultimately responsible, right? Not me. Is that correct? I just wanted to talk to her before to complete our record because I know that you don't want.
Go ahead and complete the record.
Judge, for two purposes, it is relevant and the effect upon the listener, which is obviously not hearsay purpose. Also, Judge, not hearsay purpose is the state of mind of the declarant, Mr. Norman. And that's our completion of our record.
Okay. This is occurring after the death of Andre Montgomery. It does call directly for hearsay. It is not an exception to the hearsay rule that you are suggesting. You are offering it for the truth of the matter in the court's view. So again, I'm going to sustain the objection.
And Judge, we move for a mistrial.
Ain't no mistrial.
The motion for a mistrial will be denied.
Again.
Thank you. And then the proceedings resume in open court.
Pose another question for the witness.
Yes, thank you, Your Honor. Oh, sorry. Yes, thank you. Okay. Do you know how big the funeral was?
I think it was maybe around 100 people.
Do you know who paid for the funeral?
I'm supposed to know that? I believe Tim and Miss Robbie.
Okay, I want to ask you now. This is my last set of questions. What? Okay, I want to ask you about my client, Mr. Tim Norman. How long prior to March 2016 had you known Mr. Norman?
Just after he got out of jail? Okay. Probably about 10 or 15 years.
Okay, and in that 10 or 15, how often did you get a chance to interact with him?
A lot of times. A lot of times.
Would a lot of times be every day?
Well, I used to work at a club, bounce at a club, bounce. So if he showed up at the club, he would speak, "Hey, what's up, big dog? How you doing?" Stuff like that.
Okay, do you remember who it was that actually hired you to work security at Sooty Pie?
Camel Hips Tim.
Okay, and so what you just mentioned about bouncing at the clubs, was that outside of your relationship with Tim or in addition to?
That was outside my relationship.
Okay. Did Mr. Norman ever hire you to do any other security jobs besides working security at the restaurant?
Here we go again.
Objection. Relevance, Judge.
The objection is sustained.
When you mentioned that you interacted with him often, do you get a chance to know my client very well?
Yes.
As an employer or as a personal sense?
Both.
Let me ask you, as an employer, could you please describe the jury how he was?
Objection. Relevance, Your Honor.
The objection, again, is sustained.
Aren't you tired of
Could
this?
you please describe to me how he treated you as an employee?
Same objection, Judge.
The objection, again, is sustained. This is going on and on.
Aren't you tired of this?
Did you get a chance to notice any of Mr. Norman's spending habits while you were with him?
What do you know? Objection. Relevance.
The objection is sustained. She's really striking out.
The same question, but during the period of 2016 specifically.
Same objection.
She figured if she changed the year, that made a difference.
Now you're asking about spending habits. I don't even know what that means. But the objection is still sustained.
So that's when Judge Ross, this was so funny to watch though, but he was losing his patience because you notice he didn't even say those type of things he would say when they did the sidebar. He wouldn't say that in front of us as the public, but he was over her and she was stumbling and everything else. It was crazy.
Understood, Judge. Would the court indulge just 1 second? Mr. Chandler, could you please describe to the jury what was Mr. Norman's character like?
Objection to relevance, Your Honor.
Counsel, here we go again. Will you approach the sidebar, please?
Go to your favorite spot. Time out.
Yes.
So when so even when she was going through her documents, she was literally like reading, and although the way we're reading it sounds like she was asking one question after the next, she was stumbling and like pausing and flipping papers, and like it wasn't a smooth flow. You could tell it was almost like she was in class trying to do her first argument in court ever. Like it was bad. It was real bad. I was like, I can't believe this is supposed to be his attorney. That's why I always thought she was new until I looked her up and saw that. So maybe it's part of her tactics. I don't know. Or maybe it's her first trial on that level. But anyway, the proceedings were held at sidebar. That's where they put the white noise. Us as the public, we could not see or hear it. Well, we could see it. We couldn't hear it.
Now, it is an improper question as you phrased it. So I'm going to sustain the objection. I don't know where you want to go with that. I thought I'd call you up here to the sidebar to understand what in the world, what the question is going to be. But as phrased, can't you get this through your head? It's improper. It is not admissible. So the court is going to again sustain the objection.
Your Honor, The character and truthfulness of a potentially personality trait of the defendant is relevant. And here we have a witness who has laid a foundation.
Let me stop you. First of all, the question you ask is, tell me about his character. That is an improper question. So if you want to pose another question that is proper, then I'll certainly consider it. So that's all, dear lady, that I can tell you. The question that you have asked is improper.
Okay, understood.
No, you don't.
The court will sustain the objection.
Then court and this
Pose another question, counsel.
and court resumes in open. Well, proceedings resume in open court. Let's continue with the circus.
We're gonna be right back here again.
Thank you, Judge.
Pose another question, counsel.
Sorry. Thank you, Judge. Mr. Chandler, are you able to tell the ladies and gentlemen of the jury what the character for truthfulness of my client has?
Objection. Foundation and relevance. Please help her.
Why y'all being so hard on her? She did try to reword it.
The question improper in any wording. She's
The
not
objection
getting
to the
it.
foundation
Oh,
is again sustained.
Your Honor, I can rephrase that. Same question. Well, within the year 2016.
Objection.
We were
Foundation.
at this point. We were chuckling in the court. We were trying. It was like watching a comedy show in that moment. Like we were trying to hold back because he didn't. You know, we couldn't give real reactions and stuff. They didn't. If you had to make noise and all that, they would put you out. But this was hard.
Yeah,
this was hard.
Idiot sandwich.
What in the world?
The objection is sustained.
Mr. Chandler, in the time that you knew Mr. Norman, were you able to opinion about the character of his trait for truthfulness?
Same objection, Judge. Come on.
The objection to the form of the question is again sustained.
Mr. Chandler, throughout the time period that you knew Mr. Norman, are you able to give us an opinion about what is Mr. Norman's trait for truthfulness?
What are you not getting? Same objection, Judge.
You must think I'm stupid or something. Approach the sidebar again and take your seat.
So the proceedings were held at sidebar again.
Can I leave the stand at this point?
It is not my role to tell you how to phrase a question. You're supposed to have learned that in school. As you are phrasing it, it is my view that there isn't a foundation for your asking that question. I don't know what else to tell you. Like what
understand. I'll rephrase it.
Are you?
Again, you have made an objection to the last question to the foundation. Tell me in what respect you think the foundation is lacking.
I don't think there has been any foundation as to this man's relationship with the defendant Norman to testify as to his capacity or a trait for truthfulness. All he can say is that he worked security for them.
Okay. All right, I'll accept that.
Okay, if I can briefly respond to that, I narrowed the timeline in my additional question. He has already established that he interacts with him daily, that he knows him for 10 or 15 years. I mean, I think it is someone who is qualified to be able to talk about his reputation for truthfulness and his reputation for peacefulness.
I don't necessarily agree about the truthfulness or the reputation for peacefulness. Agree with all of that, but you can pose a question.
Then the proceedings resume in open court.
I'll rephrase my question, Your Honor. Thank you. Um, Mr. Chandler, do you know of the reputation for truthfulness for Mr. Norman?
Oh, it's my turn to speak finally? You're out the corner? Oh, yes.
Objection. Cause for hearsay.
The objection will be overruled.
You can go ahead and answer.
Just speak a little louder.
Sure.
Thank you.
His reputation for truthfulness, Mr. Chandler?
Oh, it's my turn again? You're not in trouble at the sidebar? Yes.
Can you speak to it and let the ladies and gentlemen of the jury know?
What do you need? I mean, can you rephrase the question? Like, what do you need to know?
Yeah, we just want to know if you can describe to the ladies and gentlemen, the jury, what Mr. Norman's reputation for truthfulness is.
I mean, he's always been truthful to me. You know, if he says he's going to do something, then he did it.
Pose another question for the witness.
That was a horrible question. If she's
It
trying, I
was.
see what she's trying to do, but she went about it all the wrong way.
He sure did.
Thank you, Judge. I'd like to ask, I also like
Here we go.
for you to explain to the ladies and gentlemen for the jury any examples of reputation and peacefulness from my client has.
I might answer.
Objection. Foundation.
The objection again is sustained, darling.
Mr. Chandler, are you able to speak to the reputation and peacefulness of my client?
Same objection. Foundation.
The objection for the 100th time is sustained.
Your Honor, may we be heard at the sidebar?
Mm-mm.
Lord, LAWD.
Okay, here we go again. Approach the sidebar.
Then the proceedings were held at sidebar.
Your Honor, it is the same question, just posed as for peacefulness.
You, my lady, have not laid any foundation for asking that question.
Again, the foundation was already laid by him, having worked with him. Do you want me to re-ask all of these questions?
Please don't.
No, for goodness sakes, no. I'm telling you that you have not laid a sufficient foundation to ask him about his reputation for peacefulness. Don't you get it?
Okay.
And then the I'm sorry, this guy is numbing my brain. The proceedings resumed in open court.
May I ask another question, Your Honor?
You may.
In the instances that you had seen Mr. Norman, have you testified that you have already seen him pretty often, correct?
You've asked me this already, but I guess I'll say yes.
And I had asked you, was that daily?
Just about yes.
Okay. In those instances where you had seen him, have you ever seen him do anything violent?
No.
Have you ever seen him do anything that was rageful?
No.
Have you ever seen him do anything that was cruel?
No.
Are you able from time to time time that you had known him, are you able to explain to the ladies and gentlemen of the jury what his reputation was for peacefulness?
Here we go again.
Well, as far as peacefulness, I mean, he didn't get into any kind of confrontation. I mean, pretty much that was my job. If there's a problem, he would pretty much tell me, can you resolve this problem? He pretty much kind of stayed in the back and low key. So he was, yeah.
Pose another question to the witness, please.
I have no further questions. Thank you, Mr. Chandler. The government will ask you some questions now.
Whew.
Thank you. I'm glad that's over.
Me too.
Ms. Danis, questions of the witness?
Yes, Your Honor.
And then why is she acting like she had to let him know that the government was going to ask him questions?
A
That's
real
messed
lawyer.
up. Right.
A real lawyer.
And then he's talking about how peaceful Tim is. We want to talk about that lawsuit from that chef who said he punched him out.
Right. She opened the door for.
Right. Okay. Okay, we're moving to the cross-examination of Ed Chandler, aka Big Ed.
Good afternoon, Mr. Chandler.
Good afternoon to a real lawyer.
Can we pull up the last page of Exhibit 2E? I'm sorry. Go to the previous page. Previous. Mr. Chandler, did you learn that Andre Montgomery had been murdered around 8 p.m. on March 14, 2016?
I didn't know anything until I got down to the police headquarters.
And you went to police headquarters because Mr. Norman sent you these text messages telling you you needed to go. Is that correct?
He told me to call his mom. He told me to meet her down at headquarters ASAP.
And we previously spoke with you on October the 5th, 2020. Is that correct?
Correct.
Did Mr. Norman tell you that he was out of town when Andre was killed?
Yes.
That's not true, is it, Mr. Chandler?
What do you mean?
Mr. Norman was at the airport at LAX, or I'm sorry, in St. Louis when Mr. Montgomery was killed. Isn't that true?
I don't know anything about that.
You don't know anything about that?
No.
But he told you he was out of town.
Yes.
Thank you.
Any other questions of the witness?
Yes, Your Honor.
Oh, Jesus. Why, Lord, why?
Mr. Chandler, was Mr. Norman in fact out of town during that time period?
As far as I know, he was.
Thank you. No further questions.
Ms. Danis, any other questions of the witness?
No, Your Honor.
Okay. May this witness be finally excused.
Yes, Your Honor.
Does the government have any?
No, Your Honor.
You can step down, sir. Thank you, counsel. Can I see you at the sidebar?
And the proceedings were held at sidebar.
I just want to make sure I'm correct. You have no other witnesses.
Correct. Nobody for today.
So I'm going to send the jury home. We will take up a few issues that we have to take up on the record. Anything else at this time?
I just want to complete our record for the offer of proof with respect to Mr. Chandler. If he had been allowed to testify, he would have testified that he was instructed by Mr. Norman to be armed for the funeral. That is clearly a non-hearsay statement reflecting the state of mind of Mr. Norman. And it is also to explain the actions for Mr. Chandler, the effect upon the listener. Clearly not hearsay. So that's why we want to offer that to complete the record. And again, renew our motion for mistrial.
You are talking about him being armed at the funeral after the murder. That is the subject of our case, correct?
Judge, you have repeatedly allowed the government time after time to let in evidence of Mr. Norman's state of mind after the murder, including at the funeral. You even let them ask Miss Griggs about how he acted at the funeral. And you have let multiple witnesses testify about his state of mind.
I don't to sit here and argue.
I understand.
Thank you, Judge.
Proceedings then.
Ladies and
Proceedings
gentlemen.
then resume open court.
Ladies and gentlemen, I have been advised that there are no more witnesses today. So you're going to get out of here early on Friday. Hopefully, you will have a nice weekend. Now, I want to talk to you about the weekend. And first, let me give you an update on our schedule. As I indicated to you, I think yesterday, we are ahead of schedule. I anticipate that we are going to finish the case probably Wednesday, but we are ahead of schedule. So that's good news, hopefully, for you. Now, obviously, I'll continue to keep you advised to the best of my ability. Over the weekend, over the next couple of days, again, there is a temptation to be asked by people about the case. I just need to emphasize to you how important it is. You cannot talk to anyone in any manner in person, by email, on a blog, on a social media site. You can't talk to anyone about the case. And you just have to know that and understand it. As I told you, after the case is concluded, the court has received the verdict. I'm going to relieve you of that admonition. You just cannot talk to anyone about the case in any manner. So I just want to emphasize that to you and just need you to remind yourselves about that. Remind your family, members, and friends. I want to read the admonition to you during this recess and every other recess. Do not discuss the case among yourselves or with anyone else, including your family and friends. Do not allow anyone to discuss the case with you or within your hearing. Do not discuss also means do not email, send text messages, blog, or engage in any form of written, oral, or electronic communication, as I instructed you before. Do not read any newspaper or other written account. Watch any televised account or listen to any radio program on the subject of this trial. Do not conduct any internet research or consult
I'm
with
sorry, I
any
was
other
muted.
source about the case.
Hold on, Robert.
Robert.
We're gonna skip this part just because we're trying to move through it, because this is the jury instructions that he gave at the very beginning, and he's gonna give them every time they take a major break. So this is all telling them what they should not be doing outside of once they leave the courthouse and all that good stuff. Court will be back in session, blah, blah, blah. Let me see. Okay, so then we're just going to jump down to line 22, where it says, at 2:22, the proceedings stood in temporary recess. And then we continue with Judge Ross.
Court will be back in session. I want to take up a few issues that we have. We had talked about the defendant's offer of proof as it relates to Russell Lew. Again, the defendant had provided a notice of intent to call an expert. The government had filed a motion in limine asking the court to exclude the expert, Russell Lew. And I had indicated to defense counsel that I would give you an opportunity to make an offer of proof. You chose to do that in writing. I had an opportunity to review that. I will note for the record, let me ask, anything else you wanted to add with regard to Russell Lew?
No, Judge, unless you have specific questions. I'm saying that the court raised an issue that you thought our disclosure was different or broader than our initial disclosure, which we did that because of the government's objection. It wasn't fulsome enough. So we made it fulsome enough. And then they complain that it's too fulsome. I would point out that the court that they gave absolutely no disclosure of the opinions of their expert, and they repeatedly untimely disclosed discovery and opinions. So we believe that the standard should apply to both sides.
Anything else you want to tell me about the government's position as it relates to Russell Lew?
No, Your Honor.
The disclosure was untimely of Russell Lew. It is not in conformance with the requirements of the rule. Really, the disclosure amounted to a CV and a brief one-sentence statement. I had noted that the offer of proof was different than the one-sentence statement in the notice. It appears to the court that, first of all, you talk about an offer of proof that would testify as a common practice, routine practices. The only part of the offer of proof that appears to be the subject, perhaps, of an expert opinion deals with insurable interest. And that's not really the relevant issue in the case. The one thing that all of the insurance policies show is that it is identified on the insurance policies that Mr. Norman was the uncle of the insured Andre Montgomery. The government's claims, allegations with regard to the wire fraud, mail fraud, and even as it relates to the conspiracy to commit murder have to be with misstatements that they allege in those policies, including constantly giving a resident address as a location of one of the Sweetie Pie restaurants, giving a phone number for Andre Montgomery, which appears to be the phone number of Mr. Norman. They have alleged incorrect, inconsistent, fabricated information in the insurance applications. None of that has to do with whether or not Mr. Norman had an insurable interest as the uncle. So again, the court finds that the disclosure was untimely. It is not in proper form. In any event, I have considered what's set out in there, and it is unclear to the court whether or not it has relevance to any of the elements of the offense. Again, the evidence as it relates to the alleged mail fraud, wire fraud, fraudulent life insurance policies has to do with whether or not Andre Montgomery participated in the submission of those policies, whether or not the information was consistent and truthful. The failure to follow through the providing additional information, again, as it relates to issues related to whether or not he had had a medical exam. If you had a primary care physician, it is not listing all of the allegations with regard to the fraud. But the point is that none of that relates to whether or not he had an insurable interest. So again, based on the untimeliness, the lack of compliance with the rule, and again, the questionable relevance of the opinion, the court is going to grant the government's motion and exclude Russell Luce. The next issue that
Judge, in light of your ruling, we would move to have the court instruct the jury that all of the testimony elicited through the insurance agents about the subject's insurable interest should be stricken. They should disregard it.
that isn't to say that as it relates to an insurable interest that it may not be relevant. They are references that almost in a different context. So that request is going to be denied. Now, the next issue that you have raised has to do with a motion that you have filed against the court for an order directing pretrial services to accept service of process as it relates to Mr. Yagnam. With regard to that motion, again, the court believes that that would be improper and not appropriate. I don't believe that the court has the authority to order pretrial services to accent a subpoena for someone else, even someone who is under their supervision. You did provide at a break an order that was issued by a judge in the Western District. I have done some additional research looking into that order and other orders around the country as it relates to this. Now, actually, exactly on point, I have not located that. I know the government hasn't necessarily had a response, an opportunity to respond. I don't know whether or not you want to tell anything about this motion.
Who's Miss Carol?
Oh, is that me?
No, that's me. That's
Oh,
me.
sorry.
Wait a minute. What page is that? I'm sorry, I skipped it.
146 and line 20.
Okay, thank you. Your Honor, really, the government takes no position one way or the other beyond believing that the authority is readily distinguishable. But the government defers to the court's assessment of this motion and does not oppose or object to it.
Where are you?
Oh, now it's your turn, line 25 on page 146.
The court, page 146, Robert.
Line 25.
126.
Sorry, 146. 146.
146, page 25.
You need help?
146, what line?
Page line
25.
25. Yeah.
Oh, I mean, the court certainly recognizes that under the compulsory finance process clause, the defendant has an absolute right to subpoena witnesses. And if a witness is served with a subpoena, and had the witness, Mr. Yagnam, in this case, been served with a subpoena and failed to appear, I would certainly compel him to appear by issuing a body attachment. He has not been served. I noted for the record that the request for the subpoena for Mr. Yagnam, the subpoena wasn't even requested until September the 6th, which was the first day of the trial in this case. The subpoena was emailed by the clerk to defense counsel on September the 7th. So at most, you have been trying to serve him with a subpoena for a day and a half or perhaps 2 days. I don't know exactly how many. You have referenced in the motion that you have made multiple attempts. I don't know whether that's true, but I do believe that that's not much of an effort to get Mr. Yagnam served with a subpoena. Would encourage you to continue to try to get him served. If he is served and fails to appear, I'll certainly issue a body attachment. The court believes that, and one of the issues for the court in some of the cases around the country is, would the witness provide material testimony? And I do believe that Mr. Yagnam potentially would provide very material testimony in this case. The government also has some affirmative duty under certain circumstances as it relates to compulsory process and to produce witnesses in this case. And I looked back at the record again, and I would note that Mr. Yagnam was released on bond by the magistrate judge. There were conditions of the bond that were set. The only requirement is really that he remain in the Eastern District of Missouri. So I don't know whether or not he is in Hannibal or in Cape Girardeau or where he is in the Eastern District of Missouri. As I indicated before lunch, I had denied a motion to travel about a week ago where he was seeking to go to Kansas City for work. Now, in any event, when I give consideration to all of that, the government does, under certain circumstances, have an affirmative duty pursuant to the compulsory process clause to make efforts to produce a witness. It doesn't appear to the court that there was a cooperation agreement. I don't know exactly what the government's ability to produce a witness is, but I'm going to direct the government to contact Mr. Yagnam's attorney and use their best efforts to produce him. Mr. Yagnam and the attorney on Monday at 9 o'clock. And I don't know whether those efforts will be successful because, again, I have no way of knowing where Mr. Yagnam is. But again, I'm going to direct the government to use their best effort to contact the attorney and secure his appearance here by 9 o'clock on Monday morning, again, along with his attorney. Again, I'm going to advise defense counsel that you should continue to try to serve him. And so that's going to be the order of the court as it relates to the motion that you filed. So I'm going to show for record that the motion is denied in part and granted in part, to the extent, again, that I'm directing the government to use their best efforts to produce the witness. I believe that those are the one other outstanding issue before we broke. You asked about conditions in Genevieve County with regard to visiting Mr. Norman over the weekend. They have indicated to me that they will use their best efforts to make him available, and that to make him available, and they are again subject to the order that I had issued, so that you could have those visits. They're going to comply with that order. So that's what they've indicated to me.
We appreciate those efforts. Thank you.
That being said, anything else on behalf of the government?
No, Your Honor.
Anything else on behalf of the defendant?
No, Judge.
As long as we are here and on the record, I may as well go ahead and make the record with this regard to Mr. Norman's right to testify or not testify as he chooses. Mr. Norman, You have an absolute right to testify or not testify as you may choose. It is totally up to you to make that decision. I would urge you to talk to your attorneys, listen to their advice. Ultimately, it is your decision whether or not to testify or not to testify. If you choose not to testify, no inference of any kind will be drawn from your refusal to testify. Again, it is totally up to you. We are in the defense case, and so I thought it appropriate, as long as we had time today, to cover that. I don't know whether or not there is any record you want to make with regard to that. Mr. Leonard, Ms. Rodriguez?
So this part of it was, again, the jury had been released for the weekend, and they were having this discussion in open court, but we as the public were still sitting there. So I remember when this was occurring, and he just started talking to Tim from the bench, and Tim was sitting at his counsel's table, and so yeah, he was just talking to Tim in front of everybody. Mr. Leonard, not yet, Judge.
And Mr. Norman, do you have any question about that of me?
Nope.
No, you don't. Okay. All right. Again, anything else on behalf of the defendant?
No, Judge.
Anything else on behalf of the government?
No, Your Honor.
We will be in temporary until 8:45 Monday morning.
Thank you. And then
Transcript.
proceedings conclude. Cass, do y'all want to take a break before we get into that next page?
I'm good.
Anybody
I'm
need
good.
Okay.
The next transcript.
Yeah, we got to move to the next transcript. Let me pull this one down. Stop sharing. Had the other one. I always feel good when we move to a new transcript.
I
feel like we're making progress.
Facts.
Yeah.
What page are we going to?
We're going to volume 5, but let me pull it up first because I don't know off the top of my
I
head.
don't think I have volume 5.
I do.
You should have all of them because I sent them all in that last email, but it was like 2 weeks ago now. So,
Okay.
but
Yeah, on April 10th.
Yeah, do you have it?
Hold on, let me pull up my email.
Okay. Yeah, you should have all of them now. I just sent them to everybody.
I have all of them.
Okay. We got this. Why am I way down here? Let me see. Volume 5. Who's touching? Christopher Carroll. So yeah, we get right into page 1.
Wait a minute. Hold it just a bit.
I'm not. What's that?
I was calling my wife. I'm stuck at volume 4.
Okay.
Oh, okay. I got it.
Okay, good. Oh.
Marjon?
Give me a second.
Okay, we good.
I have them in my document.
Share screen. And then here.
I have to wait for him to send it to me. I mean, Vell, are you sending volume 5?
We have it already.
Yeah, I sent the email like 2 weeks ago, but if you need me to resend it, let me.
I never got it.
There was an email dated on 4/10.
4/10?
Yeah. Thanks, Shamika.
Give us a moment, Tim.
We're good.
Vell?
For the audience, I have the Andre clip. I think it's got a look. Oh no, I got to show it in. Never mind. Y'all just hold on.
You said we're gonna start with Carol. Who we're gonna be? Who are we doing?
Yeah, Christopher Carroll is Margin.
Oh, okay. Oh, all right. Rocky, be quiet. Let me go put my dog up real quick.
Okay.
Are your dogs in the court also?
Mm-hmm. Think she walked away.
Oh.
Let's see. Am I in the right email? Let's see.
Yes, Robert. You know how he likes to make an appearance most of the time, but I put him up.
He likes to make an appearance,
Yeah, you heard him? He just barked. He heard, yes. You know Rocky is all bad, so.
All right, I'll allow him in my court.
Mm-hmm.
Oh my goodness. I'll be right back. He's so bad.
He wants to be a witness.
He knows Camel Hips. He knows Camel Hips is guilty.
Yeah, he knows, and he wants to say it.
Yeah, Margin, you're on this email, but I'll resend it forward. It's your love email address. Okay. Okay, so everybody should have it. And then let me pull in the longer one. Okay, audience, we'll be right back after this break.
Dre came back the last time from being in St. Louis. He wasn't living with Robbie at the time. He came back and he said, Mom, he said, if anything ever happened to me, just know that Tim did it. What are you talking about? He said, well, just know Tim don't never do his own dirty work. But I got that fatal call from her about Dre. And I didn't want to answer the phone. You know, I just didn't want to answer the phone. And then she hung up and she called right back. And then that's when she was like, well, you know, the detectives was here. And already my heart is already slowing down, you know, and to the point where they want her to go down to the morgue to identify that was him. That was it. You know, it was like, it was so surreal. Everything just rolling around. I'm just like, not my son. You know, not my son. Not my son.
So the plan with this is like what we're doing now. I just want it to be a conversation, and you know, I like for us to start at the beginning and kind of work through the timeline of Dre's life, who he was, the parts that the public didn't get to know about him. And my goal with this whole project is to pay tribute to Dre and highlight his life in a way that I haven't seen it done anywhere publicly. And there are a lot of people who are still very invested in Dre and his life, how he impacted, you know, all of us in his brief time on the screen. So I just want to basically create something that is a tribute to him and will be something you and your family as well as the public can look to for years to come, just to celebrate Dre and his life?
I'm not doing it for no fame or fortune, because you don't really hear about how this thing happened. It's not normally in the Black community. Andre didn't have buku money. All he had was himself and his personality. And that went further than anything possibly could be out there.
So with Andre's father, how did you guys meet?
I met Dre in San Diego. I met him in San Diego through some friends. And he was funny. Andre is a spit image of his dad. Look like him, act like him, talk like him, walk like him. Andre, he was just like his dad. Spit image. Matter of fact, after Andre was born, I was out. And the nurse was like, you have to name him. I said, okay, I'll name him. I don't know, something happened and I sleep. I was out. When I woke up, they came in and said, well, here's Andre. I said, who named him? He said, I named him. Oh, okay. You are his father.
Right.
He named him Andre LaJuan Montgomery Jr. So, and he was so proud, kind of like the Lion King. He was like lifting him up extra. I'm telling you, Dre is spit image of his dad. Spit image of him.
Happy birthday to you. Ja, ja, ja. Happy birthday to you. Happy birthday, dear Mama Henry. Happy birthday to you. Eat more chicken.
I was muted. We're back. I don't think the cast knew I was doing the private chat because we don't really use it, but I'm gonna check and see if everyone is available by pulling them up. Have we done it before? Okay, yeah, I see Precious here. Okay, Precious. Okay, but Robert's not on screen yet, so I don't know if Robert ready. Let me see. Okay, we're bringing in. Let me do this. Robert, Shamika, Margin, and Mocha Barbie, and then I'm gonna do my screen share again. Here we go. I got the wrong thumbnail up. All right, is everybody back?
Everybody's
Can
back.
you hear
Yes.
Robert?
We're
Sure
here. Can you hear me?
Yes, we're
Yes,
back.
we can. Sure can.
Yep.
All right. So we are starting our next. This is now day. What day was this? Day 4? Yeah, day 4, September the 12th. This is on a Monday. And we had the whole weekend, and then we're back. There was still a lot of speculation that Miss Robbie was going to testify. That's what we kept hearing. And then that first week went by, and we heard she was going to testify on Friday. And then Friday came and went, and then it was like, okay, well, she must going to testify next week. And then I think by Monday or Tuesday, she just came and sat in the audience with us, and we were like, oh, she's not testifying, because they can't sit in the audience until after they testify. So once Big Ed testified and walked out of the court and gave Tim that nod, Tim gave him that head nod, like good job from him testifying and saying Tim was perfect and was peaceful. Tim gave him a nod like good job, and then the following days, Big Ed was in the court sitting in the audience, and he was acting as Miss Robbie's security most days, if not every day, but most days for sure. Okay, so it's time to get started. Let's move down to page 1, line 2. It says proceedings commenced at 9:14 a.m. Somebody's got their volume a little up or something, because I'm hearing like some feedback. Then we get going with Robert. Judge Ross?
Do you have feedback coming from me?
No. I'm not sure exactly where it was coming from, but I don't hear it now.
Okay. Good morning. We are here and on the record outside the hearing of the jury. Over the weekend, there were a number of motions that were filed. I want to address some, if not all of those, before we get the jury in. The first motion that I want to take up is a motion to compel the testimony of Chris Carroll. I understand Mr. Carroll is here with counsel.
I'm gonna do Mr. Martin. I don't think he talks at the same time, Mr. Leonard. But if it becomes a conflict, somebody else can take Mr. Martin. But for now, I'll do it. Jim Martin on behalf of Mr. Carroll.
Okay. And if you will bear with us for just a moment, this was a motion filed by defense counsel Mr. Leonard. Ms. Rodriguez, Ms. Killian, you have filed this motion. I understand that Mr. Martin, in response to a subpoena that was served on Mr. Carroll, indicating Mr. Martin indicated on behalf of Mr. Carroll that he intends to assert his rights under the Fifth Amendment and refuse to answer questions. And again, I understand you have filed your motion to compel. I guess as an initial matter, outside the hearing of the jury, it would be my intent to have, because the right to refuse the answer is personal to Mr. Carroll, my intent would be to make a record on that. Have Mr. Carroll be sworn as a witness. Mr. Martin, you are here with the witness. You can answer the questions that he may have, if he has any, but it would be my intent to make record with regard to that. And then I'll let you, again, you have filed a motion for the court asking the court to compel him to testify on the theory that because he sat down with investigators 2 years ago, that someone that waived his right to assert the Fifth Amendment at this time. We will take up that aspect of it, and I want to take it a step at a time. So it would be the court's intent, again, pursuant to this motion, to make record outside the hearing of the jury with the witness. Have the witness come up, be sworn, and you can ask questions. So if that's an agreeable procedure, any objection to that procedure?
No, Judge, as long as we get a ruling from you ultimately on the waiver pursuant to the Eighth Circuit case that we have cited.
I'm going to give you a ruling on that.
Understood, Judge.
Any objection on behalf of the government with regard to that procedure?
No, Your Honor.
Then, Mr. Carroll, I'm going to ask you, first of all, Mr. Martin, let me ask you, is it correct that Mr. Carroll was properly served with a subpoena in the case?
Mocha, I noticed I had Martin assigned to you in our notes.
That was okay. Do you want me to continue? Or?
Yeah, go ahead, because I'm not sure if it'll start conflicting with Mr. Leonard in a minute.
Okay. Hold on 1 second.
Okay. I'll do this part, though. I don't think so, Your Honor. It was actually just left at his house. It was not served on him, but we are here to resolve the issue.
Okay. Any record you want to make with regard to the procedure that the court has identified that it is going to follow?
Just for
So,
the record. Oh, go ahead.
do you want me to read it or do you want somebody else to read it?
No, you have Mr. Carroll. Just for the record, obviously, any questions would be asked. Mr. Carroll is going to be instructed not to answer based on the Fifth Amendment.
And I understand that that's your position. Again, it is Mr. Carroll's right to make that decision. Again, he can follow your advice or he cannot follow your advice. That's up to Mr. Carroll. So it is the court's belief that what needs to occur at this time is for Mr. Carroll is to be sworn. Take the witness stand. I'm going to give you an opportunity. If you want to be next to him up here on the witness stand so that he can ask you a question. If he needs to ask you a question, you can answer it. You can advise him. But it is ultimately up to Mr. Carroll to make that decision.
I understand.
So with that, Mr. Carroll, I'm going to ask you to step up here. The clerk will administer the oath. Just have a seat. Speak into the microphone. It will help amplify your voice.
Yes, Your Honor.
And counsel, you may proceed with questions of the witness.
Okay, thank you, Judge. Then Christopher Carroll was sworn in. This gets good. Please state and spell your name for the record, sir.
Christopher Carroll, CHRISTOPHER, Carroll, CARROLL.
Do you have any nicknames that you are known by, sir?
No, sir.
First lie, white boy Chris. Do you know that you are known within Sweetie Pie's restaurant as White Chris or White Boy Chris?
I would assert my Fifth Amendment right.
Because you just called it a lie. Okay. How old are you, sir?
52.
Where do you reside?
Farmington, Missouri.
How long have you lived there?
3 years.
Did you grow up in the St. Louis area?
I did not.
What area did you grow up in?
Springfield, Missouri area.
Are you married, sir?
Yes.
I want to call your attention to the calendar year 2015. At some point during that year, did you obtain employment with a restaurant named Sweetie Pies?
I exercise my Fifth Amendment right.
Approximately what month did you begin your employment with Sweetie Pies?
I want to exercise my Fifth Amendment right.
For the court reporter purposes, just to make sure I'm fully done before you begin answering, okay? Did you work at a Sweetie Pies location here in St. Louis?
I exercise my Fifth Amendment right.
Did you hold a position of manager at Sweetie Pies?
I would exercise my Fifth Amendment right.
Did you have supervisory responsibilities for a number of Sweetie Pie stores in the St. Louis area?
I would exercise my Fifth Amendment right.
Did those stores include one location on Manchester in St. Louis?
I exercise my Fifth Amendment right.
Did those responsibilities include one for a store located on Lindbergh in St. Louis?
I exercise my Fifth Amendment right.
And approximately how long were you employed by Sweetie Pies?
I would exercise my Fifth Amendment right.
Did your position with Sweetie Pies change at all in 2014 or 2015?
I exercise my Fifth Amendment right.
Did you continue to be employed by Sweetie Pies in the calendar year 2016?
I exercise my Fifth Amendment right.
Did you continue to hold the same position with Sweetie Pies during the time period from January of 2016 until the time of the murder of Andre Montgomery in March of 2016?
I would exercise my Fifth Amendment right.
Would you explain for the court your duties and responsibilities on behalf of Sweetie Pies in the calendar year 2016?
I would exercise my Fifth Amendment right.
Are you familiar with my client, the defendant, James Norman?
I would exercise my Fifth Amendment right.
He wouldn't even admit to knowing Tim. You understand that he went by the name of Tim, is that correct?
I would exercise my Fifth Amendment right.
And was he the one that hired you for Sweetie Pies in 2014?
I would exercise my Fifth Amendment right.
And how long had you known Mr. Norman prior to March of 2016?
I would exercise my Fifth Amendment right.
I want to call to your attention to March of 2016. But before I get there, I want to ask you some questions about Andre Montgomery and Travell Hill. First of all, were you familiar in 2016 with Andre Montgomery?
I would exercise my Fifth Amendment right.
He is asking these questions like he's actually getting answers. Were you familiar with Andre Montgomery in 2015?
I would exercise my Fifth Amendment right.
When did you first meet Andre Montgomery?
I would exercise my Fifth Amendment right.
Great. Was he considered in 2015 a full or part-time employee of Sweetie Pies?
I would exercise my Fifth Amendment right.
Excellent. At what location did he work for Sweetie Pies?
I would exercise my Fifth Amendment right.
Excellent. Approximately how often in 2015 and prior to his death in March of 2016 did he work at the Sweetie Pies restaurants?
I would exercise my Fifth Amendment right.
Great, great. Did it come to your attention as an employee of Sweetie Pies from any source that there had been a robbery at the home of Miss Montgomery?
I would exercise my Fifth Amendment right.
Interesting. Did you discuss that robbery or burglary with Miss Robbie Montgomery?
I would exercise my Fifth Amendment right again.
Are you familiar with Tim's mother, Miss Robbie Montgomery?
I would exercise my Fifth Amendment right.
Great, great. In response to the alleged burglary at her home, were you asked to take any steps in regards to Miss Robbie's home?
I would exercise my Fifth Amendment right.
Mr. Martin? Yeah, no. Judge,
do you want me to read it?
no, Miss. I got it. Judge, for the record, without contacting me, when counsel made contact with my client, he informed him he was only going to ask him 3 questions. We are certainly well beyond 3 questions. So when he was asking white boy Chris these questions, he was actually turning to his attorney occasionally and seeing what he could and couldn't say. And pretty much after he answered those first few questions, everything was like, don't answer them. Mr. Leonard says, well, that's just not true, Judge. You know it's true. You know it's true.
I don't necessarily, and I've said this before, want to get into an argument about that. I have allowed you to ask a number of questions. I just want to ask you, Mr. Carroll, as to any questions related to Sweetie Pie's restaurant, your employment there, Ms. Montgomery, Mr. Norman, Andre Montgomery as to any questions as it relates to any of these people. Would you answer to any question? B, that you would exercise your Fifth Amendment right and refuse to answer these questions?
Yes, Your Honor.
Is there any question that counsel could ask of you as it relates to your employment, your knowledge of Sweetie Pie's restaurant, or any of these individuals that have been asked about? Is there any question that you would not exercise your Fifth Amendment right to?
No, Your Honor.
And
Judge, it is a very limited issue. I want to make sure we have on record. Okay. I understand the court's concerns, but we didn't ask about Vell Hill and what would be the main objective of Mr. Carroll's testimony. It is just a couple questions, Judge.
if you have a couple of questions as it relates to Vell Hill, go ahead.
Sure. Sir, are you familiar with a gentleman named Vell Hill?
I exercise my Fifth Amendment right.
Great. Prior to the date of Andre Montgomery's murder in 2016, did you have any communication with Vell Hill about the murder of Andre?
I exercise my Fifth Amendment right.
Spectacular. Did you have any discussions with Vell Hill prior to the murder of Andre about any monies that might be paid to him to participate in that murder?
I exercise my Fifth Amendment right.
Beautiful, beautiful. Did you attend in-person meeting with Vell Hill in March of 2016 at which anything about Andre Montgomery was discussed at that time?
I exercise my Fifth Amendment right.
Interesting. A week or so prior to the murder of Andre, did you have any text communications with Tim Norman?
I exercise my Fifth Amendment right.
Beautiful, beautiful. Were any of those text communications in reference to Andre Montgomery?
I exercise again my Fifth Amendment right.
Good, good, good. Judge, I think we have perfected a record on that.
Well, okay.
Okay.
If you say so. Any other record you want to make with regard to Carroll at this point? And again, I'm going to take up your motion.
Sure. It sounds like you want me to cease my questioning.
I'm saying he has clearly indicated that he is not going to answer any questions as it relates to Vell Hill, Robert Montgomery, Andre Montgomery, Tim Norman, any other witness that you have identified or has involvement, employment, in Sweetie Pies. Is that correct, Mr. Carroll?
Yes, Your Honor.
Okay. Based on that record, the court is going to indicate to you to step down. If you will remain in the courtroom for just a moment.
That's still you reading.
Oh, that's me?
No, that's still Robert reading.
Oh, sorry.
In the courtroom for just a moment. Mr. Leonard, again, I know you filed a motion against the court to compel Mr. Carroll to answer the questions. Anything else you want to tell me? I have had an opportunity to review the motion.
Sure, Judge. Our position as a matter of law is that, as we've cited in our brief, Mr. Carroll was interviewed first on October 19th of 2020. Present was Detective Rudolph, along with possibly another agent from the St. Louis homicide and possibly a federal agent. That meeting was extensive. It lasted approximately 1 hour. That's not extensive. Okay. Mr. Carroll was given the opportunity to have counsel. He knowingly and voluntarily waived his rights and decided to proceed. He answered questions on all of the subject matters that you have referenced, Judge, including all the questions that were asked today. Specifically, he answered in detail about his lack of involvement in any alleged meeting with Vell in March of 2016 or at the time prior to thereto, where the discussion of Andre Montgomery came up. After that meeting, Judge, and our position would be right there. He has waived his right to later assert his Fifth Amendment based upon that voluntary decision. Secondly, Your Honor, in March 11th of 2021, Mr. Carroll voluntarily, intentionally, and knowingly agreed to step forward again to submit to, again, a lengthy interview. The first one in length was an hour or so. I believe the second was similar. We cited the 302 in our submission. We are also asking the court to allow us to file under seal the audio transcripts. So there is no question upon review as to what subject matters and questions he agreed to answer that day. And on March 11th of 2021, Your Honor, again, he met with Detective Rudolph, who was accompanied by another member of the St. Louis law enforcement or a federal agent. Again, Mr. Carroll waived his right to counsel, waived his right to assert his Fifth Amendment privilege, and then proceeded to answer for an hour or so, Your Honor, questions on the very subject matters that were posed to him today, and as well as specific questions that were posed to him today. So our position would be that, again, that was a second voluntary waiver of his Fifth Amendment right, which he cannot assert now. Secondly, as a matter of law, Judge, as we've pointed out in our briefing, Mr. Carroll is not in jeopardy. He has a pending PPP case, which has nothing to do with the subject matter of this action. Mr. Carroll has already twice stated to the police detectives in clear and uncertain terms on probably 30 different occasions during those interviews that with regard to the alleged meeting that Mr. Hill says he participated in with Mr. Carroll in March of 2016, that meeting never occurred. Mr. Carroll was not there. Mr. Carroll did not discuss with Vell Hill at any time any idea of paying any sum of money either directly to directly by Mr. Carroll. And there is no discussion that Mr. Norman wanted him to pay anything. And there was no discussion that Mr. Carroll said to Mr. Hill allegedly that he thinks you are charging Tim too much money. Mr. Carroll was asked that question about the meeting approximately 36 times over the two interviews. In particular, in the second interview, which lasted about an hour, that was essentially the sole focus of the hour session, where the agents repeatedly asked about the particular meeting. He waived his right, but he is not in jeopardy, Judge. If he gives a truthful answer or an answer to that question, he is not in jeopardy.
Mr. Leonard, I understand your point, and I'm going to grant you leave to file the sealed tape to preserve the record as you have requested. Let me go ahead and ask the government if they have a response.
Thanks, Judge.
Ms. Carroll? Ms. Carroll?
Your Honor, the government has no position on this motion to compel.
Judge, we do. I have some case law if that would help.
Mr. Martin, you are on behalf of the witness. You are here on behalf of the witness. If you will approach the podium, I'll give you an opportunity to tell me what you want to tell me.
Thank you, Your Honor. First of all, as to the argument of jeopardy, it doesn't matter what Mr. Carroll would say. It is what others have said that clearly makes him in jeopardy. And therefore, he has the right to exercise his Fifth Amendment right. The motion filed by the defense counsel in this case cites several cases that talk about exercising your Fifth Amendment too late. Each of the fact situations of those are when someone went ahead and talked and then months later tried to say, but I was doing it under my Fifth Amendment. But they had never expressed that. Those courts say, including the Eighth Circuit opinion, that it is too late to claim that you did it under the Fifth Amendment. In those cases, they were being persecuted or pursued for failure to cooperate, or it was used as evidence in one case. It was used in the sentencing that had failed to cooperate, and they tried to argue. But we exercised our Fifth Amendment, and the court said, you've never said that when you were interviewed, and therefore it is too late to make that argument now. As to the fact situation of giving interviews to the agents, and then later on exercising one's Fifth Amendment rights, and what I was able to get last night, I got a case directly on point from the 10th Circuit. And if you go specifically to page 9, the court specifically addresses the concept of, does someone waive their Fifth Amendment because they earlier interviewed in, I'm sorry, somebody's got background noise throwing me off. Hold on, I'm gonna mute everybody. Okay. The court specifically addressing the concept of someone waiving their rights to the Fifth Amendment because they were earlier interviewing, and it specifically holds no. The potential to waive somebody's right to Fifth Amendment when you have said something earlier relates to testimonial waiver. You have had to testify in the same proceeding to not be able to exercise the Fifth Amendment later within the same proceeding. There was no proceeding. It was not testimony. It was not under oath. And the 10th Circuit clearly says that it does not in any interview, to agents, does not negate the ability to exercise one's Fifth Amendment rights.
Thank you, Mr. Martin.
Thank you.
Again, the court has had an opportunity to review the case law as well. Again, the motion was filed over the weekend. And just based on my review of the case law, the evidence the court is going to deny the defendant's motion to compel Mr. Carroll to testify. The fact that he waived his right under the Fifth Amendment and agreed to speak with investigators at an earlier time does not forever constitute a waiver of his right to exercise the right to remain silent under the Fifth Amendment. It does appear to the court that although defense counsel is suggesting that he has no jeopardy, that based on some of the testimony that the court has based in this case, that he potentially does have jeopardy. And again, simply the fact that he waived his right to refuse answer questions at an earlier time during a police investigation. Law enforcement investigation doesn't mean he forever waives his right to exercise that privilege under the Fifth Amendment to refuse to testify. The witness has taken the witness stand. He has exercised his right to refuse to answer questions. The motion to compel his testimony is going to be denied. As it relates to Ms. Killian, I have heard the arguments.
Just could the court read the citation into the record for the case cited by Mr. Carroll's counsel?
I'm going to give you a copy of it. It was given to Mr. Leonard.
Understood. Thank you.
Anything else as it relates to Mr. Carroll?
Yeah, just briefly, Judge. As you recall, this sort of dovetails back to your consideration and ruling on motions we have filed in limine prior to the trial with respects to the Brady issue that we raised. Just so it is clear to the circuit, to the court, and Carroll's statement, and the audio recordings again were produced to us for the first time on August 26th. That motion was denied in terms of being Brady material. The government then was allowed to proceed to trial in their opening statements and through witness testimony to present a distorted and misleading set of facts to suggest that the jury that no meeting between that there was a meeting between Mr. Carroll and Mr. Hill, and that they didn't have not disclosed. I don't know. And would like to make an inquiry on that based upon this ruling that they have knowledge that Mr. Carroll's position is that no such meeting occurred. So they are able to present a picture to the jury which is untruthful, and they know what Mr. Carroll makes. He would want to make an inquiry of Detective Rudolph, the fact that he had notice or knowledge of these statements, not for the truth, but for the effect upon the detectives and the lack of investigative insight into that. And just for the record, Judge, I respect the court's ruling based upon the denial with respect to Mr. Carroll. We would move for mistrial.
The motion for mistrial will be denied. Ms. Carroll, I don't know, or Ms. Danis, whether or not you want to respond to any of that. It is really re-raising the Brady issue that the disclosure was in violation of the Brady.
Precious? Oh, she muted. I muted everybody. I don't know if Precious is still there. I'll read it.
I'll go.
Oh, okay. Thank you.
Your Honor, the government would just rest on its previous submissions on this matter and the court's earlier determination. I don't believe anything that has occurred in the last hour has changed any of those issues, Your Honor.
Okay. Again, it is the court's view that, again, I understand, Mr. Leonard's, your argument, but I don't believe that it changes the court's view as it relates to the disclosure. It was timely, and it has been disclosed. It is available. I don't see any purpose in inquiring of Detective Rudolph. It would be offered for the truth of the matter, and it just would clearly just be offered for the truth of the matter and not to explain subsequent conduct. So again, I'm not going to go back and forth with you, Mr. Leonard. I have ruled on the motion, sir. So Mr. Carroll can be excused at this point in time. You have still been with a subpoena. If something changes, I'll notify counsel, or the attorneys will notify counsel.
Thank you, Your Honor.
The next motion that was filed was a motion to compel Mr. Yagnam's testimony. I guess my first question of you is to have you serve Mr. Yagnam.
Okay, and we're going to end here because we're at an hour 45, and it's time to roll into my next show. So we're going to stop here on, what is this, page 19, line 7, and then we'll continue next time with the conversation about YL Yagnam, because it goes on with that as well. But I thank all of you for joining us again as we have returned to our transcript reading. We're making some progress. And we're wrapping it up slowly but surely. It's wrapping up. But any final words from it looked like Robert just dropped. No, here's Robert still, just off camera. Robert, any final words?
Happy birthday to you. Happy birthday to you. Happy birthday, dear Vell. And many, many long days to you.
Thank you, Robert. I appreciate that. At first I was like, whose birthday did I miss? But thank you for the belated birthday wishes. I greatly appreciate it. Sounds great. Sounds wonderful. I
You're
appreciate
welcome.
it so much. All right. I will talk to you later. You have a great evening. I appreciate that.
All right.
Okay. Bye-bye. And Mocha, I think, is off. But wait, no, here's Mocha. I don't know what happened to Mocha. Shamika, final words?
No, thank you for letting me read again, and I look forward to next time. We'll see you at the next show.
All right, I'll see you soon. Thanks so much. And then Mocha, if you're there, I'm not sure if you're there.
I'm here. I've been having some connectivity issues. There's a thunderstorm going on in my area, so that's why I kept dropping out.
Okay.
Coming back in, so I apologize for that.
No,
but nothing really I wanted to say other than the first 12 pages of Miss Rodriguez was just hilarious, trying to answer that one question and put it like 87 times.
God. It really did take me back. It took me back to that moment. It was crazy being there in real life. It was crazy.
Yeah, but other than that, I look forward to next week.
All right, we'll see you next time.
All right, bye.
Okay, bye-bye. And Precious, any final words? I think Precious, I don't know if she's been gone. Yeah, Precious might have had to dip out on us. So we'll see Precious next week. Last but not least, Margin.
Oh, thank you for everything. Sorry I misread some stuff, but we had a long appointment.
Join the club.
And I had told Robert
I misread too. Join the club.
Sing you happy birthday because he wasn't there last week. So I had asked him to sing you happy birthday and happy belated birthday again.
Thank you.
And I believe that by next time this year, you're going to have 100K on both channels.
Amen to that. I'm
and you're going to be a millionaire by this time next year also.
All right. Well, I'm definitely claiming that. I appreciate the prayers and well wishes.
Thank you so much. I'm so proud of you, Will, for everything. You're such a nice young man. I feel like you're my younger brother in my head, but I'm so proud of you on so many levels, and I'm sure your mom is too.
Yes, she is. Thank you so much, Margin. All right, we'll talk to you. I'll see you in the next show.
Yes, sir.
All right, y'all. For the sake of time, I will see y'all next time. My plan is for us to be here next Wednesday. We're gonna try to do at least hour 45, 2 hours, so we can get through this. But I am about to hop right on over to the main channel, Vell B Reacts, and we're going to do the Paula Zane reaction. I have no idea how I'm about to try to pull this off, but join me over there. I'll figure it out. All right, y'all. With that, y'all have a great evening, and I will see you next week. Yeah, that's it. Make sure to like this video and hit that subscribe button if you haven't as of yet, and share this video. Well, share it. Yeah, you can share it. I guess you can share it. All right, I will see y'all next time. Peace.